The 37th Circuit Court is now in session with the Honorable Brian A. Kirkham presiding. Today is Monday, March 20th, 2023 at 8:36 a.m.
Good morning, Ms. Brown.
Good morning, Your Honor. How are you?
Doing well. And you?
I'm great. Thank you.
You can proceed whenever you're ready.
Thank you. Before the court is Sarah Smith on docket 2015-1125 DP. Ms. Smith failed to appear on May 6th of 2022 for a show cause hearing before referee Bradfield. Currently, her bond is set at $1,344. This is her 9th warrant. Her last payment was June of 2021, and that was a $300 bond. Friend of the court is asking that the next hearing be scheduled March 29th at 8 a.m. before Your Honor.
Ms. Smith, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing. When's the next hearing, Ms. Brown?
March 29th at 8 a.m.
March 29th, 2023 at, well, is it 8 or 8:45? We don't have any at 9.
It's at 8.
8 o'clock a.m.
Yes.
You will get notice of that in writing. Ma'am, are you able to post a bond?
No.
No? Okay. Well, the court does note that it is your 9th bench warrant, and you have not, again, paid for a considerable period of time, for years, in fact, other than being able to collect the bond money previously. What I'm going to do, I am reducing your bond slightly. I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay, thank you, ma'am. Ms. Brown, we're getting a lot of reverb on you, so that's why I can't hear some of the stuff you're saying, but it's not your problem. We've had some issue with our speaker.
Okay.
Go ahead when you're ready.
Okay. Now before the court is Charles Witcher, docket 1998-2171 DP. Mr. Witcher failed to appear on March 4th of 2019 for a show cause hearing before referee Fryer. Currently, his bond is set at $6,095. This is his 4th bench warrant. His last payment was a bond that was posted in November of 2021. Friend of the court is asking that his next hearing be scheduled on March 29th at 8:45 a.m.
Thank you. Mr. Witcher, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing be held on March 29, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not.
Okay. Well, the court notes that it is your 4th bench warrant in this matter, and again, that you've not paid in a considerable period of time, for a matter of years, in fact. As a result, the court, I will reduce your bond, but I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
Nope. Nope.
Okay. Court will conclude this matter at 8:40 a.m. You're free to go. Have a good day.
All right.
That's all we have, Your Honor.
Okay, thank you.
All right.
Thank you. Have a great day.
Yep.
See you later.
Bye-bye.
We're going to go to the Andrews case. Okay, can everybody hear me?
Yes.
Yes.
Okay, all right. This is case 2022-2305 DM Alicia Andrews versus Anthony Andrews. Today is Monday, March 20th, 2023 at 8:41 a.m. Attorney Katie Reed represents plaintiff. Plaintiff is attending via telephone.
Okay.
Yes.
Good morning to everyone. Yes, I'll ask first, Mr. Andrews, as I note in this matter that you were defaulted on October 18, 2022. Are you disputing or contesting anything in this matter?
Just the child support.
Okay, well, what you're gonna have to do is you're gonna have to file some paperwork to contest that. What the court will do, the court will take the proofs. I will hold up entry of the judgment for a week. I'll give you a week to file whatever it is you have to file, sir, to dispute this matter. If you don't file within the week, the court will enter the judgment at that particular time. You understand that?
Yes, Your Honor.
Okay. Miss Andrews, I'll have you raise your right hand. We're going to have you sworn in. We'll take some testimony.
Okay.
You can lower your hand, Mr. Andrews, just for her. Ma'am, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Go ahead, Miss Reed, whenever you're ready.
Thank you. Ms. Andrews, can you hear me okay?
Yes, ma'am.
Okay. Can you please state your name and spell your last name for the court's record?
Alicia Ray Andrews, Andrews.
And Alicia, do you recall coming into my office in August of 22 to sign a complaint for divorce?
Yes.
And were the allegations contained in that complaint true and accurate at the time?
Yes, ma'am.
And do they remain true and accurate today?
Yes, ma'am.
You state that there had been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that your marriage can be preserved. Does that remain true today?
Yes, ma'am.
And you also stated you'd lived in Calhoun County at least 10 days and you'd lived in the state of Michigan for at least 180 days. Was that true at the time that you filed the divorce complaint?
Yes, ma'am.
And you've had a chance to review the judgment that judge will enter in this matter?
Yes, ma'am.
And do you believe that the provisions contained in that judgment as they pertain to custody and parenting time are in the best interest of your two minor children?
Yes, ma'am.
And do you believe that the property allocations are fair and equitable?
Yes, ma'am.
And one last question, are you pregnant at this time?
No, ma'am.
Thank you, if it may please the court.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. Court will preserve the proofs in this matter pending any action taken by Mr. Andrews in the next week. Again, Mr. Andrews, if you don't file any paperwork in this matter, the court will enter the judgment and the UCSO a week from now. So court will end this matter at 8:45 a.m. You're free to go. Have a good day.
Thank you.
Thank you. Thank you.
All right. This will be the Woods case, but the problem is we have no other parties except the plaintiff here.
Is Glacier here?
Oh, that's Mr. Glazier in the office. Okay. Mr. Glazier, is Mr. Woods, Joshua Woods, planning to appear?
No, this is a pro-con. They're in agreement. We submitted a consent judgment of divorce to be executed.
Okay, very good then. So let me call this case. This is case 2022-2524 DM Ellie Woods versus Joshua Woods. Today is Monday, March 20th, 2023 at 8:46 a.m. Attorney Matt Glazier represents plaintiff.
Good morning to both of you.
Good morning.
Ms. Woods, we're going to take some testimony from you. So if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Go ahead, Mr. Glacier, whenever you're ready.
Okay, Ms. Woods, would you state your name and spell your last name for the record, please?
Ellie Woods, Woods.
And you came into my office about September 20th of 2022 to have a discussion about a divorce. A complaint was prepared and you signed that complaint. Is that correct?
That's correct.
And then that complaint was filed with the court. You and your husband have had discussions about a divorce. You've decided to go forward with the divorce. So in that complaint, we allege that the objects of matrimony had been destroyed. I'm sorry, the marital relationship had broken down such that there remains no reasonable likelihood that the marital relationship could be preserved. Is that correct?
That's correct.
And can you briefly tell the court what led to the marital relationship breakdown?
Josh and I just grew apart. Our marriage grew apart.
Okay. And so you and he have been discussing things and matters, and you reduced the resolution to a consent judgment for the court to sign. Is that correct?
That is correct.
And the copy that we submitted to the court, you reviewed that, you signed it, I signed it, and there was a signature line that was for Joshua. Have you seen his signature in the past?
Yes.
And was that his signature on the signature line that bears his name?
Yes.
Okay. Likewise, there's a child support provision and paperwork addressing that as well. Is that correct?
That is correct.
And likewise, his signature appears on that, as does yours.
Correct.
Okay. And you're asking, so the total of the consent judgment as well as the child support documents, that completely resolves all the issues in the marital estate. Is that correct?
That is correct.
Are you asking the court to enter that order?
Yes.
I believe I've covered basics, Your Honor.
The court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The file is in order. We do have a consent judgment of divorce and UCSO signed by all of the parties and their respective attorneys. As a result, the court will enter that, which I have done now. Ms. Woods, you are divorced. Good luck to you. I hope everything works out for you. And the court will end this matter at 8:49 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Right.
No,
So Judge, we have no one for the Hamilton. Do you want to say something for that case?
No, we don't need to on that.